Hi, I'm Debbie Moraes. This is, once again, Legal Matters, the program that's designed to address timely, critical, and sometimes contentious issues facing businesses and families today. It's legal information, it's practical information, it's straight talk about a wide range of topics from bankruptcy and finance and family law to Social Security, workers' compensation, mediation, and more. In our last segment, we came to you with a live studio audience seated at the Bristol County Courthouse and State House in Bristol, Rhode Island. We once again want to thank the Bristol State House Foundation and also the Mosaico Community Development Fund. We also need to thank our producers from Full Channel again. Our attorneys again, Jackie Grasso and David Bazar from Odette Bazar Cordero Grasso Law Firm in East Providence. When we had our last segment, we began talking about wills, estates, and probates, and we covered the big picture. Today we're going to look a little bit more deeply at the process of probate and also address some of the specific issues and questions that were prompted by that. Also, laws are changing and they will be impacting some of your decisions for some of you anyway. So let's get going. That probate process. I believe you started telling us that not everything's in probate, and there are apparently some assets that are distributed outside the probate process. What's a non-probate estate? What's all that about?
All right, we can talk about that, but first let's say it was fun to be on the road.
Yeah, we actually enjoyed it.
We did, but
Look forward to more.
It's good to be home too.
Yeah, it's good to be home in the studio.
So probate assets or non-probatable assets. What we were talking about last time is that assets that you don't have to change the name on to pass don't have to go to probate. For example, life insurance policies. There's generally a beneficiary named who would be the recipient of the policy proceeds. Now, sometimes that person has died, and depending on what happened, if there's no beneficiary named, it may go back to the estate, so that has to be probated, or it may name the estate itself. But generally, if a husband names his wife or children as beneficiaries of his life insurance policy, that policy passes directly to the children without the need for probate. Another example would be IRAs. Many times when you have an IRA, you name your beneficiary just like you do in a life insurance policy, and it passes directly by, I'm going to call it almost by contract, by agreement. It goes to somebody without the need to go through probate.
Also, any assets that are held jointly. Any joint bank account that would immediately pass through probate, and by passing through probate, in other words, it's not subject to distribution in the probate court. So anything where you have a joint account, real estate, if you have real estate that you own with your spouse, it's getting into a different area.
But let's talk about it a little bit.
So you can own real estate in several different forms. One is a husband and wife, which is called a tenancy by the entirety. It's only exclusive to husband and wife. So upon the death of the spouse, it automatically vests to the other spouse, regardless of what a will would say.
And let's just quickly talk about the benefits of a tenancy by the entireties. As Jackie said...
Is that the same as joint tenancy, David?
It's
a
not.
little different.
Okay.
Joint tenancy has a right of survivorship, but it's not exclusive to husband and wife.
Okay.
Husband and wife can have a joint tenancy. I think years ago they used to do them.
Well, it depends on...
not always
and you
utilized.
still can.
Yeah.
The difference is very simple, and it's... if a husband and wife own property as joint tenants, then they're treated just like other joint tenants. If the husband dies, the property passes to the wife. If the wife dies, the husband passes to the property. It's the right of survivorship. Tenancy by the entireties gives some protection against creditors. So if the husband is sued and an attachment is tried to be made on the property that's owned tenancy by the entireties, the attachment fails if he dies and the property passes to the wife. So it's actually some protection against creditors. That's in addition to the other benefits.
How does someone have a tenancy in its entirety? How do you physically do that? Is that something that's done in a town hall?
No, when you prepare the deed is the document that you get when you buy a piece of real estate that says Jane sold to John, putting it very simply. When Jane sells to John, you own as one person, which legally we call in fee simple, which means you own it alone. If Jane passes to John and, give me a girl's name. Mary, as husband and wife, then you have to declare it in a deed. You would say, as husband and wife, as tenants by the entirety. So you would have to put it in writing, the deed then has to be recorded. Now, there's some case law out there that says if it doesn't say tenants by the entirety, there are actually some case law, some cases say they're going to construe that as a joint tenancy, and some cases say no.
Tenants in common.
Yeah.
Yeah, tenants in common is actually, I think, what's considered the default position. So if you don't say joint tenants or tenants by the entirety, it becomes tenants in common, which then would have to go through probate, because if Mary and John owned the property as tenants in common and Mary died, her property, that interest in that property passes to whoever she leaves it to, not by the deed operating to give it to the survivor.
So in that case, you would have to look at the will. If there isn't a will, then you
Right.
look at the intestate statute.
Correct.
Very complicated. But I've understood that people have said joint tenancy seems like such a simple, automatic way for a husband and wife to go. It keeps things simple. They just jointly own it, passes, they have equal shares, and it just goes on. Apparently, that's not entirely the case and not always the case. Is there a tax advantage to having property in joint tenancy versus some other way of doing it?
I think, let's distinguish between the two, and correct me if I'm
Yeah.
wrong. If a husband and wife own as joint tenancy, either the husband or wife have the right to transfer their 50% interest during their lifetime. And during a tenancy by the entirety, you cannot transfer your interest because exactly the two of you own as one.
Right,
So
and-
that's not a transferable asset during your lifetime.
break-
Point of clarification.
To
Yes.
break a tenancy by the entireties, you either have to get divorced or you
Exactly.
both have to transfer the property. But I
Okay.
guess what I was trying to follow in your question was, go ahead.
The tax issue portion of that. And while this isn't meant to be a tax segment, could you at least address the issue about
Okay. And tax on death or
Tax,
otherwise?
if something is held in joint tenancy, what are the tax implications? Is it sometimes better to have something probated rather than just in joint tenancy?
Well, okay.
And she's talking about the step-up.
To separate basis, yeah. But here's the issue on that. If it's between husband and wife,
Yes?
there's no tax on the death of one spouse or the other if it's left to the spouse. The marital deduction reduces any
They
taxes.
call it an unlimited spousal
Right.
deduction.
So,
Okay, that's a good point. All right.
so then the issue on capital gains is if a husband owns a piece of property jointly with his wife and he dies and it goes to her, there's no step up in basis. She owns it for the same value that they bought it together at. However, she does, if she were to sell it and it's her primary residence, have that exemption that you would have as a primary residence when you sell a property and there are capital gains. And here's what's interesting. See, if they sell it as a couple, I think it's $500,000 exemption. As a single person, it's $250,000. So there are some tax implications, but I don't think it makes all that big a difference on the sale if they're both alive and they're selling it, whether it's tenants in common or joint tenants.
No.
But if it's joint tenants, she won't get that step up in basis. Will she get it tenants in common? That would be an interesting issue because I guess it would go into his estate. So there is a possible
There would be a
step up in basis.
I think, on 50%. of it.
50%.
Just let me clarify that a little bit, maybe just be a little easier for our viewers to understand. What David means by the step-up in basis is when you buy a piece of property, and I'll use my parents as an example. In 1965, when I was born, my parents bought a piece of property. They paid $16,000 for it. Today, we're in 2010. If they sold that property today and it's worth above $516,000, in other words, if they sold it for $600,000, they would be paying capital gains on the difference between your basis, which is the original amount you bought it
16.
for, and the amount you pay, the amount you're selling it for. So there's a huge tax ramification. And sometimes when people want to just transfer deeds during their lifetime, what they don't understand is when you transfer a deed during your lifetime, the person you transfer the deed to actually takes your basis.
Takes the basis,
Of-
the original basis.
of the
That's what the
transfer
code
of.
is.
And
Yeah.
here's where it becomes a problem. And the problem is this: if someone comes to me with children, they want to take the house totally out of their name and put it in the children's name.
Yes.
And it's not where the children live. They don't get that
Primary